Okay, good morning everyone. This will be my video lecture in NSTP 2 no, for Block A and Block B. Today is March 6, 2021. It's a Saturday morning. So before I will start lecturing on the continuation of the different provisions of the Bill of Rights, I'd like you to have with you your Constitution, no? Because every provision that we will be discussing today is found in the Bill of Rights. So I stopped last time in section 14.1, no, about due process of law. But before we will finish the discussion of the provisions of the Bill of Rights, I'd like to give you your assignment. So this one will be assignment number 6. Assignment number 6 would be, which you have to put in your folder, assignment number 6. No? So this is assignment number 6. Put in your folder. Number 1, discuss the meaning. Meaning, when I say discuss, it has to be in detail. Now, discuss the meaning of community engagement. So we start a new topic by Saturday. What is community engagement? And then secondly, what are the characteristics? What are the characteristics of a good community engagement? So there are only 2, but you need to discuss them thoroughly. Okay? So I'd like to discuss now about section 14.1, which is no person shall be made to answer for a criminal offense without due process of law. Well, we talked about the due process of law last time. When we say due process of law, we talk of the 2 aspects, the substantive aspect and the procedural aspect. And these 2 aspects must concur. When I say must concur, meaning to say it has to be present. The opportunity to be heard on the part of the accused has to be given or accorded to him by law. And this is a constitutional right. So definitely, each time that there is a prosecution, a criminal prosecution against the accused, it is required that he should be given an opportunity to be heard. And how is that? Well, the opportunity to be heard, of course, is that he will have his day in court to defend himself and be able to know the causes or grounds of the accusation against him. So there should be a specific provision of law that he has violated because of the substantive requirement of due process. No, there is a substantive requirement of due process, which means to say that you have to specify the particular offense which constitutes a violation of a particular provision of law. It could be special law or the revised penal code. The revised penal code is where you could see all the criminal offenses that are committed by a person. No? So I have discussed this before. The due process of law would have what we call substantive aspect or the substantive requirement, which is the law, the legal basis. And the procedural aspect would be, of course, there should be a trial. There should be a hearing. And in the trial or hearing, the issues to a certain controversy or a certain prosecution will have to be fleshed out accordingly. Okay? So we proceed with section 14, number 2. In all criminal prosecutions, the accused shall be presumed innocent. Well, this is very basic. No? In every criminal prosecution, very basic, no? The accused, the accused meaning acusado, no? The accused is presumed innocent. Now remember this, under the law, you cannot say that, hey, you committed the crime. The accused is always presumed innocent unless what? Proven otherwise. Unless proven otherwise. What it means is that you have to prove the offense committed, you have to prove the offense committed through evidence. No? There should be evidence. Hindi mo siya pwedeng sabihin, uy, nakikiapid ka. No? Without giving evidence for the commission of a crime or a felony. No? Or you will say, uy, matako ka. You cannot do that. No? There should always be a presumption of innocence on the part of the accused. Once you say that he did commit a certain crime, well, prove. No? Prove by evidence. Evidence, no? We talk about evidence here. You have to prove that the accused is guilty by the presentation of evidence. And in criminal prosecutions, when we talk of evidence, by evidence yung represent mo, in criminal cases, the quantum of evidence is always proof beyond reasonable doubt. No? So para ma-convict yung akusado, the proof that you will give should be beyond reasonable doubt. Meaning, walang kaduda-duda na he committed the crime. Well, if you cannot prove beyond reasonable doubt, he may be exonerated. And there is no conviction at all. You understand? So the quantum of evidence, when we say quantum of evidence, we are talking about, say here, we talk about evidence, the quantum, no? We say quantum of evidence, the quantum of evidence, or weight, the weight of evidence, or gaano karaming ebidensya kailangan mo. Well, it has to be proof beyond reasonable doubt. When we say proof beyond reasonable doubt, dapat walang pagdududa whatsoever that he was the one who committed the crime. No? In civil cases, ito criminal cases, no? Here, proof beyond reasonable doubt. But in civil cases, the quantum of evidence required, civil, yung mga civil na cases lang, like about lupa-lupa. In civil cases, the evidence required would be preponderance of evidence, no? Just sufficient to show that there is enough evidence to prove a certain issue or fact. Preponderance of evidence. Hindi siya proof beyond reasonable doubt. Ito yung mabigat, no? Yung proof beyond reasonable doubt in criminal cases. Okay, you understand? Preponderance of evidence only in civil cases. Well, we discussed about section 15, the privilege of the writ of habeas corpus. It will not be suspended. What do we mean again by the writ of habeas corpus? Habeas corpus, to translate that, would be produce the body. Meaning to say that if a certain person or individual was accused or akusado siya, no, of a certain crime, the authorities should be vigilant about the production of that person, no, the presentation of that person. Hindi mo siya pwedeng isuspend na, we cannot produce that person, etc., because we are under ganyan, no? We are under martial law. So this one, the suspension of the privilege of the writ of habeas corpus will only be during rebellion or invasion, where the public safety requires it, or it might be impossible to produce the body during invasion or rebellion. No? So, whatever time we are in, no? If we look for, say for instance, a certain accused, no, nasaan na ba yung accused na yan? Well, he should be able to, the authority should be able to present the accused at any time during the time of the hearing or trial, no? Hindi mo siya pwedeng sabihin, hindi namin alam kung nasaan, no? Okay? Section 16, all persons shall have the right to a speedy disposition of their cases. Well, speedy disposition would mean dapat mabilis, no? Yung paglilitis, no? Paglilitis ng mga kaso, it should be speedy because a long trial or hearing may be interpreted as a denial of justice already, no? So it has to be speedy, it has to be fast, it has to be done in accordance with reasonable time, no? Reasonable time. Okay? We proceed with section 17. No person shall be compelled to be a witness against himself. Well, no person shall be compelled to be a witness against himself. The proper term here is you do not want to be yung self-incrimination, no? Self-incrimination. Because the moment you speak, the moment you open your mouth, no, you may be incriminated. Meaning, baka maidiin mo yung sarili mo. So, no to self-incrimination. That's why, if you do not want to talk about your case or you do not want to discuss about your case, then you are protected by section 17. No? No to self-incrimination. No person shall be compelled to be a witness against himself. You do not want to be a witness. Why is that? Well, you also have to protect yourself. Diba? Baka kung anong masabi mo in court, that might incriminate you further. Incriminate meaning that might be a reason for you. When we say incriminate, that might be a reason for you para ma-convict. No? Incriminate, ididiin mo yung sarili mo. No? So, if you do not want to be a witness, you have the right not to be a witness because you are just invoking your right against self-incrimination. No? Okay? Next would be section 18.1. No person shall be detained solely by reason of his, well, this one happened before, no? During martial law, no? So whatever political beliefs or aspirations you may have, the government authorities should respect that. Whether you belong to, say for instance, a certain ideology, they should also respect that. Whether you belong to the Nationalista Party, to the Liberal Party, to the PDP, or whatever party you belong to, respect should be accorded to your beliefs as a person, your political beliefs as a person. Okay? Number 2, section 18, number 2, no involuntary servitude in any form shall exist except by way of a punishment for a crime whereof the party shall have been duly convicted. Okay, involuntary servitude, what we mean, diba? This is your assignment before. When we speak of involuntary servitude, ito yung term na yan, no? Involuntary, the term is involuntary servitude. What we mean by this is, although in labor code this is usually used, no? Especially for the HRDM major, involuntary servitude would mean, well, if you do not want anymore your job, no, you do not want to work anymore for a certain employer or a certain company, no one can force you, no one can force you to tender your resignation. No one can prevent you, rather, No one can prevent you from tendering your resignation as long as you have complied with the requirements of the law. And the requirement, of course, is it depends on the employer, 15-day notice or 30-day notice, depending on the employer. Then as long as you have complied with that, no one can force you to work for that company if you do not want it anymore. But of course, you have also to consider certain factors. No, what we mean by involuntary servitude is that hindi ka na mapipilit, no, to serve your employer or your company if you do not want it anymore. Anyway, you have the right to seek for other employment if that's the case. The only exception for involuntary servitude is if you have been convicted by a crime. No, exception would be if you have been convicted for a crime. In which case, yung punishment mo for serving would be, of course, imprisonment. No? Ito, talagang hard labor ka if you're in prison. This one is an exception to the rule on involuntary servitude. No? Mapipwersa ka because you are what? You are being punished for a crime that you have committed. Okay, section 19. 1. Well, it talks about excessive fines. No? Excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Of course, this is prohibited already by the Constitution. No? Excessive fines or infliction of unjust punishment or degrading punishment, because this is a violation of human rights already. Respect for the dignity of the person. Okay, number 2, the employment of physical also, no? Section 19, 1 and 2 are related. So because this one we have to respect for the human person, no? So the Constitution prohibits the infliction of punishments that are too degrading or that are unjust or cruel, because we have to respect the person. No? Section 28, no person shall be imprisoned for a debt or non-payment of a poll tax. No? Imagine that, kung may utang ka, no, you cannot be imprisoned by virtue of Section 20. No? Section 20. So mangutang ka na ng mangutang. No? Anyway, you will not be imprisoned after all. Okay? We go to section 21. No person shall be twice put in jeopardy of punishment for the same offense. Well, this is what we call double jeopardy. No? This is what we call double jeopardy. Double jeopardy. Remember this principle. No? Double jeopardy would mean you cannot be put twice for a certain crime. Say, for instance, you have been accused for the crime of rape, for instance. No? Crime of rape. No? There was trial. No? There was a hearing or trial for this case against you. Now, so what happened in this case? After the litigation was over, you were found out to be not guilty. No? Not guilty. So in short, you were exonerated. Exonerated meaning napawalang sala ka. No? Exonerated. So this one was your crime, your offense, allegedly committed by you. So if this case, if you were exonerated, yung walang sala ka, no? You cannot be accused again of the same crime of rape, no? On the same facts and circumstances, which was the basis of the first, no? Yung basis na to. So, kung na-dismiss na itong crime of rape na in-impose nyo, they cannot accuse you again for the crime of rape based on the same facts and circumstances. That is double jeopardy. No? Hindi pwedeng madoble yung pag-aakusa sa iyo. It should only be once, no? Because you know, that might delay the dispensation of justice, no? Kawawa ka naman. Okay? Next would be there's a double jeopardy, meaning for the same offense, no? Facts and same offense, you cannot be put twice in jeopardy. No? Hindi ka na, pag nilitis na yun, tapos na. No? They cannot refile the case against you. Then finally, we have section 22, no ex post facto law or bill of attainder shall be enacted. No? So this one is a call for Congress. No, no ex post facto law or bill of attainder. No? What is ex post facto law? Ex post facto. Well, this one is after the fact. Facto law. What this means is that, of course, who enacts the law? Yung mga batas, gumagawa ng batas will be Congress. Diba? So, supposing that, say for instance, supposing lang, no, that before what's this? Yung 5-6 that we call yung too high interest rate, no? Yung too high interest rate, say for instance, usury, no? Usury, for instance, usury. Supposing that doing usurious acts, usury would be yung napakataas na interest, no? Usury. No? So supposing that at that time you lent money, a usurious act, usurious meaning yung 5-6, no? Supposing that the usurious lending of money, for instance, was not considered a crime. So for instance, last year, no? So for instance, supposing this year, not this year, January 1, 2021, no? January 1, 2021, this was not, nung magpautang ka ng about 20% per month ang interest, it was not considered a crime, no? In January 1, 2021. Then later on, Congress passed a law. Say for instance, the law is March 1, 2021. This is the law passed by Congress saying that, hey, usurious lending of money is now considered a criminal act. No? Ginawa ng criminal act yung lending of money ng 5-6. Do you think you can be held liable for this law? Say for instance, new law. This is a new law. Do you think you can be held liable criminally under this law? No? Nagpautang ka, January 1, 2021, 20% per annum. Supposing that this is considered as usurious. Now, here comes a new law passed on March 1, 2021 saying that, lending of money under usurious circumstances is now a criminal act. Remember that this is after January 1, 2021. Can you be held criminally liable for this new law? The answer is no. Why is that? Because ex post facto law is not allowed as prohibited by the Constitution. Now, there is a principle in law, especially in criminal cases, no, yung mga batas kriminal, no, special laws, for instance, yung mga batas kriminal should be prospective. Prospective in nature. Prospective in nature and not retroactive. Remember this one, mga batas retroactive, not retroactive in effect. No? What do we mean by prospective in nature, prospective in effect? No? What do we mean by prospective? Prospective meaning is for future, no? For future application. This one, for because laws are prospective in nature, meaning if the law was enacted on March 1, it becomes a law on March 1, 2021. The applicability will be from March 1 up to a certain yung future, no? It could not apply on acts done on February 28, 2021 or earlier because it does not have any retroactive effect. Okay, understood? So we finished everything today under the Bill of Rights up to section 22. So your assignment, we jump to another topic which is community engagement. So I'd like you to read and put that down in your assignment about community engagement, which we will be talking starting next Saturday. And also, what are the characteristics of a good community engagement? Okay, that is all for today. Good morning, everyone.